video, we'll be covering civil procedure. The first thing that I would like to touch upon is the frequency in which civil procedure has been tested. A fun fact for you is that civil procedure is by far the most highly tested MEE subject. It's been on 71% of the MEEs since February 2011. So this is definitely a subject that you want to be familiar with because it's regularly tested. Civil procedure is usually tested on its own, but it has been tested with conflict of laws. Next, let's talk about some of those highly tested issues in civil procedure. The first one that we have to discuss is subject matter jurisdiction. The reason we can't get away with skipping over this is because subject matter jurisdiction is the most highly tested issue within the world of civil procedure. Specifically, the examiners really like to test diversity jurisdiction as well as supplemental jurisdiction. Now, that doesn't mean that they don't test federal question, because they do. It just means that they tend to favor diversity and supplemental. Before we dive into those rules, we want to give you a quick tip. We find that when the examiners test supplemental jurisdiction, they are expecting examinees to walk through the rule and analysis for diversity and federal question jurisdictions first. Thus, they treat supplemental jurisdiction almost like a jurisdiction of last resort. This is good to know because in using this approach, they give points to that discussion of diversity and federal question jurisdictions. So this means if you jumped right into supplemental jurisdiction and you skipped over those other two, you would be missing out on a ton of points. So to recap this tip, if you see supplemental jurisdiction being tested, be sure to first outline diversity jurisdiction and federal question jurisdiction, even if you do so briefly. You will be rewarded with points. Getting back to the law, subject matter jurisdiction is the court's power over the case. Turning to federal question jurisdiction first. This type of claim must be created by federal law or created by state law, but depend on a substantial federal question. The federal question must appear on the face of plaintiff's well-pled complaint. Thus, federal question jurisdiction will not exist if the defendant has a federal defense that plaintiff is anticipating. Instead, plaintiff's actual complaint must arise under federal law or it can be created by state law, but depends upon a substantial federal question. Turning to diversity jurisdiction, this type of claim has two requirements. There must be complete diversity of citizenship and the amount in controversy must be over $75,000. Complete diversity of citizenship looks to the party's domicile at the time the complaint is filed. This is the only moment in time that matters. It doesn't matter how the party's domicile changes after the lawsuit is filed. Domicile is defined as the place where someone lives and intends to stay. Individual people can only have one domicile. This is a good time to give you another quick tip. Be sure to connect the dots for the grader. If you outline the requirements for diversity jurisdiction and you do not define domicile, then you're not presenting a full rule statement. Once you outline all of your rules, be sure you have a fact or a sentence of analysis for each part of your rule. This way you know you're not forgetting anything or leaving points on the table. For the second requirement of diversity jurisdiction, the amount in controversy. Remember, it has to exceed $75,000. So if someone's claim is exactly $75,000, that's not enough. Moving on to supplemental jurisdiction. Remember my tip. Don't talk about supplemental jurisdiction until you've already discussed diversity and federal question jurisdictions first. Supplemental jurisdiction is when there is a jurisdictional basis for one claim but not another. The federal court has subject matter jurisdiction over both claims if they arise from a common nucleus of operative fact. Supplemental jurisdiction commonly occurs when a plaintiff asserts a federal claim and then wants to tack on a state law claim, or a party is added after the initial lawsuit. Our next highly tested issue is personal jurisdiction. Before we dive in, I want to clarify that personal jurisdiction is highly tested, but it's not as highly tested as some examinees think. It was not tested very often in the past, but it has been tested more frequently as of recent. So, personal jurisdiction is the court's power over the person. If you see a personal jurisdiction issue, be sure to start with general personal jurisdiction and then move on to specific personal jurisdiction. This is true even if you feel like it's clear from the fact pattern that it is a specific jurisdiction issue. As I've already stated, a big part of doing well on civil procedure questions is to connect the dots for the grader. They always start with general personal jurisdiction, so you should too. Remember that general personal jurisdiction exists when there is consent or presence or domicile. Specific personal jurisdiction arises from someone's contact with a place. It must be constitutional under both state law and federal law. It's good to write on your essay that personal jurisdiction is constitutional if the defendant is engaged in a minimum contacts with the state that would not offend traditional notions of fair play and substantial justice. Finally, be sure to use proper vocabulary and buzzwords in your essay. Mentioning things like personal jurisdiction and how it stems from the 14th Amendment Due Process Clause, or purposeful availment, or minimum contacts is key. Our next highly tested issue is venue. Venue is a discussion of which court should hear your case. Now, this is not a decision between state court and federal court. At this point, you would already know which court system you're in. Rather, venue is analyzing which federal court is appropriate to hear your case. To determine the proper venue, the law states that venue is proper where any defendant resides if all defendants reside in the same state, or in a district where a substantial part of the events or the omissions giving rise to the claim occurred. And then there's a narrow fallback provision that states that if venue cannot be established under that general rule, then venue is proper where any defendant is subject to the court's personal jurisdiction with respect to that action. But the fallback provision has not yet been tested. There are some other issues that have popped up over time on our civil procedure questions, things like transfer to a more appropriate forum, service and process, temporary restraining orders and preliminary injunctions, as well as joinder of plaintiffs. If you're not familiar with any one of those issues, I would recommend that you review them and you try your hand at some essays on those topics, as they are highly tested enough that you do want to be familiar with them. Our next tip for you is something that I've already mentioned a few times now. Connect every dot for the grader using IRAC. Make sure your rule statements go from general to specific, and be sure to apply the general rule before analyzing the exceptions. Think of it like you want to walk the grader through each and every step of your analysis, even if it feels or seems like an obvious one. Oftentimes, examinees miss points because they simply fail to state what is obvious, and this is avoidable. So always err on the side of being thorough with your analysis and using IRAC. Remember, that stands for issue, rule, analysis, and conclusion. Our final tip is to practice. Be sure to spend some time trying out a variety of different civil procedure MEEs. The added bonus is that you will likely notice your MBE score will improve as well. So that wraps up our discussion of civil procedure for the MEE Highly Tested Issues Guide.